Good afternoon, everyone, and welcome to CJJ's webinar on youth with intellectual and developmental disabilities, education, and the juvenile justice system. My name is Naomi Smoot. I'm Senior Policy Associate here at CJJ. Before we get started, I wanted to run through a couple of quick technical details. First, you'll notice that all participants are in listen-only mode right now. In order to speak, during the question and answer period, you're going to need to click the raise your hand button. And then I will unmute you, and you can ask your question, and then I will place you back on mute. There's another way to ask questions as well. You'll notice there's a questions box at the bottom of your screen. You can type in your question at any point during the presentation there, and we will read the question for you. Once the webinar has concluded, the PowerPoint and the additional resources, including the recording, will be placed on our CJJ website, www.juvejustice.org, and that should be posted within the next 24 hours. Today we have Selene Almazan and Diane Smith-Howard joining us for our presentation. Ms. Almazan has represented students and families for nearly 30 years. She is a former supervising attorney for the Legal Aid Bureau of Maryland, where she represented children in the foster care system, including representation in special education matters. For nearly 23 years, Ms. Almazan represented parents in special education matters with a primary focus on least restrictive environment issues at the Maryland Coalition for Inclusive Education. Since September 2014, Ms. Almazan has been the legal director for the Council of Parent Attorneys and Advocates, COPAA, where she supports the work of the Amicus Committee and works on federal and local policy issues. Diane Smith-Howard is a senior staff attorney at the National Disability Rights Network. She is a litigator with 20 years of experience in juvenile and education law. Ms. Smith-Howard's work at NDRN focuses on conditions for youth in the juvenile justice system and child welfare systems. In addition, she works on issues related to adults with disabilities in the criminal justice system and children and youth with disabilities that impact behavior in the public education system. Ms. Smith-Howard provides training and technical assistance to the P&A network on these issues. She has worked for NDRN's Maine and Michigan affiliates, providing direct service to clients. Thank you, ladies.
Well, I'll get us started then on slide 1, the school to prison pipeline. We're going to talk today about what happens to young people with intellectual and developmental disabilities when they're removed from school, when they enter the school to prison pipeline, and then eventually once they enter the juvenile justice system. So the school to prison pipeline is loosely defined as the term describes the increasing patterns of contact that students have with the juvenile and adult criminal justice systems as a result of recent practices implemented by educational institutions such as zero tolerance and the use of police in schools. What that means, practically speaking, is that kids leave public school through formal and informal removal, through school-based arrests and referrals into the juvenile justice system, and through more informal practices, which we'll talk about over the course of the next hour. Next slide. So the factors that we just talked about, formal and informal school removal, school-based arrest, disaffection, and unaddressed needs. I don't think it's possible to really quantify those as being more or less significant. They all work together usually in a mix. Very few kids are impacted by one only of those factors. So who's in the pipeline? 1 in 6 African American school children have been suspended at least once. That's not necessarily children with disabilities, that's just in general. More than 13% of students with disabilities were suspended twice the rate of their non-disabled peers, and 1 out of every 4 African American children with disabilities was suspended. So 25% of the population of African American kids with disabilities is suspended. So they are out of school, and in order for a suspension to count, it needs to be a significant suspension. So what does this mean practically speaking? 3 million kids in this country lost instructional seat time. Sorry, next slide. The number of children it would take to fill every seat in every major baseball park and every major league and every NFL stadium in America combined. So 3 million kids are out of school. And suspensions are among the leading indicators to whether a child will drop out of school. It increases a child's risk for future incarceration. And you see the site to the study that this comes from there. And so some people say, well, just because a kid is thrown out of school or removed from school, how does that mean necessarily they end up in the juvenile justice system? There are a number of informal ways and practical ways in which that happens, and there's also some significant direct links. When children are out of school for significant periods of time, they're often home unsupervised or out in the community. They often make connections with negative peers that they hadn't made previously because they have free time, and other negative peers are out in the community with them. They may fall behind academically and start to feel like it's impossible to catch up in school, so there's no point in returning. They may look for alternative income sources to fill what they had thought was going to be at one time a career. I mean, there are a number of reasons why kids who are out of school end up in the juvenile justice system informally. And formally, many kids end up in the juvenile justice system because they are arrested at school. And we're going to talk a little bit in a few minutes about the evidence chain issues and some of the crossover that occurs when kids are arrested or interact with school police in the school setting. So, next slide, juvenile justice implications. And then let's flip right to long-term impact. Status offenses can lead to placement. This is, some people believe that if you commit a status offense, which means doing something that would not be illegal if an adult did it, like drinking alcohol or running away from home, that you cannot be incarcerated. And that's not true. There's an exception called the valid court order exception that allows kids to be placed in facilities as a result of a status offense, or sometimes the status offense leads to a regular juvenile justice offense, which leads to placement. So those are all ways in which that can happen. Evidence can be collected at school, and in interrogation, information can migrate. We'll talk about that a little bit more in a minute. Juvenile justice records definitely have an impact on college applications, military, and jobs, in the sense that oftentimes people are asked directly on the application if they have had a juvenile record. And juvenile records are not nearly as private or as unavailable as people often think they are. There are a number of exceptions that allow juvenile records to be used and transmitted, that information to be transmitted around, particularly to the military and other places. So just because someone has a juvenile record does not mean that it was sealed and that information is unavailable to employers in the future. Kids who go into the juvenile justice facility often have medication and service disruptions. As we talked about before, they change peer groups. They're separated from family, community, and positive peers. And in many cases, children who have been in the juvenile justice system are not permitted to re-enter public school and are asked to either be placed on a homebound program or into an alternative setting, which is not an equivalent educational setting to the one that they left. So while that is an illegal practice, it is a common practice. So it may have significant educational disruption. In addition, juvenile proceedings may result in reports to law enforcement, of course, and prosecution, and educational records related to the incident may be made available to law enforcement. Juveniles, just as they do in any other setting, have a right to remain silent, the right to not incriminate themselves, and the right to counsel. All these rights can be invoked at the school level. But where things become complicated is that there is a different evidentiary standard. The Fourth Amendment does not apply to school staff in the same manner that it does to school resource officers. So if a school staff person interrogates or questions a youth at school and gets information and or searches a locker using the lesser evidentiary standard that applies to school staff, they can do more things than the police can do. That evidence is not supposed to migrate over to the police department or to the school resource officer. However, as a practical matter, it often does. So if, for example, a school principal searches a locker and finds a bag of pot, that pot is not necessarily able to transfer to the school resource officer, but it often does. So it's important when you're representing kids to ask all those questions about the evidentiary chain and how that evidence came to be. And because this is a conversation about youth with intellectual and developmental disabilities, I think it's particularly important to talk about interrogation and questioning. Kids with ED and often do admit to things that they didn't do or admit to things to protect others. And so it's tremendously important that they have appropriate representation during questioning and that all of the Fourth Amendment protections to which they have a right are applied to them. Next slide. Representation in juvenile proceedings. So does the student have counsel for the juvenile proceeding? And if so, quickly, the DNA staff person or other attorney should quickly contact counsel to determine if there's shared discovery. Juvenile counsel's concerns about the student and statements in the juvenile hearing. This is a good time to start talking about that evidentiary chain. Where did the evidence really come from, and was it rightfully obtained? And the ability of the juvenile justice system to manage, I don't know if I would say the problem, but I would say the student and his needs, because the child may have placement concerns and the IEP needs or other educational services needs that would not properly be provided within the juvenile justice system, and so he'd be better in community-based services. Next slide. So utilizing the educational system to avoid juvenile impact. Oftentimes public defenders are not as familiar as other attorneys may be about the educational services that are available to kids and their educational rights. So one place that education attorneys can assist is by providing information to the public defender about educational interventions that are more precise, what the kids' rights are, educational interventions that are ongoing, and just basically connecting the educational rights that the child has, either both to general education and special education, to the rights that the child also has within the juvenile justice system, so that those can be paired together to create a comprehensive, individualized program for that child. Next slide. All children have a right to due process when a removal from school is being anticipated for them. That's children in general ed and children in special ed. And of course, kids who are in special education or who are IDEA or Section 504 eligible are general education kids first. So first they have formal education rights that apply to all students, and then they have, in addition, other rights that apply to them as children with disabilities. Next slide. So for a short-term suspension of less than 10 days, the school principal is the one who makes the determination of the punishment. For a longer-term suspension greater than 10 days, a superintendent must make that determination. And an expulsion, which is the remainder of that school year, often is the determination of the school board. And these things are usually set out in the school code. So if you're representing a young person who has had a proposed suspension, it's really important to find out exactly how long suspension is being anticipated for, so you know what level of due process applies, and also which school code violations are being alleged, because sometimes if you ask enough questions, you might determine that it's not really clear which school code violation they are claiming was violated, which school code provision was violated, and then it makes it difficult to determine what the appropriate punishment would be, because the school code should be clear that if a child does X, that Y will happen. And discrimination and confusion can occur if it's not clear what exactly the allegation was and what the punishment for that would be. Next slide. So Goss versus Lopez is the U.S. Supreme Court decision that sets the permissible guidelines and requirements for due process around the removal of any child in public school, that public education is a property interest, and it makes clear that suspension or expulsion impacts on a student's liberty interest and that the student is entitled to due process. Next slide. So are all discipline removals entitled to Goss protections? Well, yes, but the extent of the due process provided is based on the length of the removal. For suspensions over 10 days, any student with a disability or without a disability is permitted to have notice of the charges against him or her, at least a brief understanding of the evidence, the capacity to provide his or her side of the story, and in a suspension of 10 days or more, it would be access to a formal hearing and notice of when the hearing will occur so that there's time to prepare for the hearing. And so what we see often in situations where GOS protections are violated, there will be a hearing that the child didn't know about, that the child was unprepared for, and or that sort of vagueness we just talked about in terms of what they're saying actually happened and what was a violation of the school code. So clarity around all those issues is tremendously important. In addition, children with disabilities have a right to formal due process through the IDA and or Section 504 of the Rehabilitation Act, depending on which of those two statutes they may be eligible for. So for a child with a disability who is special education eligible and eligible under the IDA, they have a right to a manifestation determination review process, which will determine whether or not the behavior that led to the discipline was caused by their disability. And there's provisions around that and specifications about what that due process must require, and that they need to have an informal hearing around that. And distinct from kids in general education, children in special education who are removed from school have a right to continue to receive the services on their IP and access to the general curriculum. Those are tremendously important protections, particularly for kids with intellectual and developmental disabilities, to help make sure that they don't fall behind while they're out of school. And there are a lot of advocacy opportunities around making sure that the manifestation determination review is done accurately and really includes all the information that's available about the child's disability to make sure that he or she is not punished for something that they had no control over. All right, at this point I'm going to hand the mic over to Selene Almazan to talk about discipline and disability. Thank you, Selene.
Thanks, Diane. So Diane made a really important point, and the point is that all students are general education students first, and they're entitled to the Goss versus Lopez protections as Diane outlined them. And it's important to remember that, because Goss versus Lopez arose out of student protests during the Vietnam War, and the Supreme Court was very clear about what kind of discipline you are entitled, what kind of discipline schools are entitled to mete out to students. So can't emphasize that enough about the Goss versus Lopez protections. And as Diane mentioned, there are there are legal protections for students who have disabilities, whether they're covered under an individualized education program or an IEP or a Section 504 plan. And part of the work that Diane and I have been doing for many years together in collaboration is looking at the nexus between discipline and disability. Diane's statistics at the beginning of this webinar are very striking, that there are so many students with disabilities who are disciplined at a higher rate, and especially children of color. So that's a huge impetus to look at a paradigm shift and look at understanding the relationship between disability and behavior, particularly for children with developmental disabilities or an intellectual disability, and looking at creating positive school environments as a means of changing behavior for students. Next slide. So there is this sort of urban myth out there that children with disabilities are immune from discipline, and that's not true. They have protection as people with disabilities. However, ensuring that students with disabilities receive appropriate services, and we're going to talk in a second about functional behavior assessments and behavior intervention plans, is not necessarily special treatment. It really is talking about slowing down the process, creating an atmosphere for conversation, and in addition to that, but recognizing the severity of the conduct where it may be appropriate. But not every behavior in a school building necessitates the intervention of a school resource officer or police. Next slide. So looking at behavior framework, the traditional behavior framework in school buildings is looking at reacting to what has happened focus on what the consequences are going to be, and looking at who the student is. You know, is this a student who regularly has infractions in school or disciplinary referrals to the principal's office? But rather looking at proactive means through functional behavior assessment and a behavior intervention plan to focus on prevention rather than just the reaction to a behavior that might violate a student code of conduct, focus on the setting and in the prevention, and then look at behavior as communication. There is a lot of literature out there and a lot of research out there that behavior is really a form of communication, and that gets you out of this idea that kids are just disruptive or bad kids or always in trouble. Next slide. If a student doesn't have an IEP, and Diane talked about the manifestation determination meetings, and they have a Section 504, manifestation does apply. So that just essentially means that if they have engaged in a behavior that is related to their disability, you need to determine whether or not there is a nexus between the two, and if there is, then the student needs additional interventions, may not be able to be disciplined and removed from the school unless it's one of three things. If it's one of three offenses that get you automatically into an interim alternative educational setting, and that is bringing drugs to school, bringing a weapon to school, or causing serious bodily injury to somebody. Those three things, even if it is a manifestation of the disability, students still get removed to an interim alternative educational setting. So looking at Section 504, look at your school system's 504 rules. Some school systems have very good Section 504 policies and procedures, and some do not. So look at what those Section 504 regulations are, and see if they've been updated since 2009 when the Americans with Disabilities Act was amended, and that included the Section 504 as well, looking at disabilities that could be covered under Section 504. It's important to know and remember that all of the original discipline challenges came out of the Office of Civil Rights on behalf of children who had Section 504 plans long before discipline was codified in the Individuals with Disabilities Education Act. So it's important to remember that. And then for students who are suspected as having a disability under the Individuals with Disabilities Education Act, the IDEA, you need to look at whether or not there was a written request for special education or evaluation. It has to be written, and whether or not a school employee made the referral. Next slide. So if a student is suspected but not yet identified as having or requiring an IDEA, the school will be deemed to have had knowledge that the student had a disability before the behavior occurred only if the parent or legal guardian expressed concern in writing, the parent or guardian requested an evaluation of the student before the behavior occurred, or, next slide, the child's teacher or other school personnel expressed a concern about the behavior. This was a change to the 2004 IDEA. Prior to that, from the 1997 regulations, it was not this prescriptive. Nothing necessarily had to be in writing, and they, when they amended the IDEA in 2004, they added this caveat that you had to have written concern to the appropriate person, which makes it more difficult for families who may not be originally from this country, makes it more difficult for families who are not native English speakers, makes it more difficult for families who may have disabilities themselves, and so that is a concern. But looking at that, you know, getting beyond that, but looking at whether or not through school records, anybody in there in school records made a note at the end of the year, perhaps on a report card, that there was a concern about a behavior or a performance of the child that went to appropriate school personnel maybe the principal, maybe the special education person at the building, but those records may end up yielding a lot of information about who had knowledge that a student may have a disability. And that's all worth looking at if a child is being disciplined. Okay, next slide. The Supreme Court in Honig versus Doe in 1998 looked at the disciplinary removals for students and looked at the history of the Office of Civil Rights investigating students for discipline, disparate discipline actions by school systems, and took this 10-day removal from Office of Civil Rights findings and said that the 10-day removal really triggers your additional procedural protections for students with disabilities, so that if you're removed from school for longer than 10 days, that triggers the need for an IEP, because it really is that you've had a change in placement. And we know from the IDEA that you are not entitled to change a student's placement with an IEP without having an IEP meeting prior to that, so that parents can exercise whatever legal protections that they may have at that time. Next slide. So if you have a child who has been disciplined and has an IEP, you need to look at whether or not behavior is already identified as a potential issue in a student's IEP. You need to look to see if perhaps there are goals that are related to behavior in school, whether that is organization, sometimes it's inattention, sometimes it's following school rules. Any of those kinds of things in IEPs are really the buzzwords for kids who are struggling to follow school rules. You know, a student who regularly leaves the classroom without permission, leaves the school building without permission, has difficulty during transitions and may lash out at other students, anything like that, where they're trying to teach kids how to wait their turn or don't shove. Anything like that doesn't necessarily have to be a behavior goal. It can be anything that is social interaction, organization, inattention, school behavior, anything like that. So you need to look at behavior and whether or not it is in the IEP. And then also know that the regular education teacher must be a part of the development of any kind of positive behavioral interventions or strategies or supports if the student is part of a regular education class. And then finally, a functional behavior assessment must be conducted if you have a child who is struggling with behaviors. I see a lot of students who have IEP goals where it's clear that they're struggling with behavior, but there's no functional behavior assessment and there's no behavior intervention plan. I recently represented a student with a genetic disorder who qualified as a developmental disability student with a label of developmental disability, and she had a significant amount of behaviors, and she was in first grade, and there had been no functional behavior assessment that had been done, even though she was out of the classroom every day after 1 o'clock in the principal's office, and they were calling the principal. So it was pretty clear that she needed a functional behavior assessment, and none had been done for her. They just complained about the behavior. So you need to look at whether or not there was a functional behavior assessment done, and then whether or not there was a formal behavior intervention plan. Next slide. And there are evidence-based alternatives to school removal. There's positive behavior intervention support, that's PBIS. There's a whole website, there's a lot of writings about PBIS. It is an evidence-based intervention. There is also restorative justice, which is being utilized in many school districts now, and many school districts have made the switch with very good results. I know that there has been a lot of newspaper articles recently about, I think that Los Angeles recently got rid of all of removals for disciplinary infractions in order to keep kids in school for all the reasons that Diane said initially. Next slide. And so looking at what a functional behavior assessment is, we're going to run through these slides because all the information is here. It's essentially to determine what the purpose is served by the behaviors and what motivates the person to engage in that behavior. Next slide. And it does assume that the behavior represents a need and that in using the behavior, the student is communicating a message. So it may be that a student is struggling with academics. It could be that the student is struggling with the environment. It could be that the student is having in a power struggle with the teacher or with another student. And so it really is that a student is trying to communicate something. And so the premise is that behavior is learned and it's reinforced by the consequences that follow it, and it can be affected by other factors. So if you have a student who regularly engages in behavior, and I had this student many years ago, he engaged in behavior in the classroom and he was getting removed. You know, he was running around the classroom, he was leaving the classroom, he was being very disruptive, and the teacher was sending him to the principal every day. And we found out at the IEP meeting that every day the principal was taking him to McDonald's for lunch. And so it became a pattern that he would engage in the behavior, he would go to the principal really liked him, and they were leaving the building and they were going to McDonald's. So it was pretty clear that that was what was reinforcing the behavior. Next slide. And this is just a graphic of functions of behavior, obtaining what you want, what you don't want, and what you hope to escape or avoid. And then it could be seeking attention. In the example that I just gave, clearly he continued to want to go to McDonald's. Next slide. And then looking at what the triggers are, looking at the data that you can collect. It's typically called antecedent behavior and consequence data, and that is just really looking at what are the antecedents, what happened before the behavior occurred, and then can you draw a hypothesis on what the student was trying to achieve through the behavior. Next slide. And behavior intervention plans can have prevention supports, teaching strategies, and response strategies. You see that all of these are really about the adults around the student and not necessarily the student. By looking at the prevention, looking at what the teaching strategies are, and then looking at the response by the adults around them. Next slide. This is just a behavior intervention plan example. Next slide. And then looking at replacement behavior. Next slide. Okay, and I believe that is Diane.
Sure. Selene, I think it's really important to talk about informal removal here, simply because we've really seen, especially within the P&A network, a real resurgence of the use of informal methods of removal. You know, back when the IDEA was developed back in the 70s, informal removal of children with disabilities for disability-related behavior was largely the reason that the IDEA was passed in the first place, protecting kids from being sent home from school or prevented from attending school in the first place. So I believe, my theory is that now that we're collecting data and holding school districts accountable for high rates of student removal, that is one of the reasons that informal removal is flourishing again. And some of the ways that we see informal removal being used, and by informal removal I mean the removal of kids with disabilities from school for disability-related behaviors without going through the formal due process that we just talked about, the IDEA and 504 protections and the GOS protections. Some of the ways that we've seen this happen are the sent homes, and it's interesting, Selene sort of mentioned some of these kinds of scenarios where kids are sent home at a particular point in the school day because they're having trouble maintaining their behavior. The increased use of homebound services, meaning that a child is sent to attend school from their home or from a sort of a neutral public building like the fire hall or the public library, where they receive tutoring by a school student staff person, but they no longer attend school in the building. use of virtual schools, meaning that the child is on homebound and accessing their educational program through a computer, the use of an alternative school, which in some cases is a very informal and non-educational setting. Some alternative schools are great, but some are not. Or in-school suspension, where the child does not receive access to educational services. Perhaps they are sitting in a room off the principal's office coloring or doing worksheets that are not connected to the general curriculum. Or the use of a shortened school day. And we're seeing a lot of shortened school days within the PNA network. So I think it's important to talk about that. That's where a child is sent home every day at a particular time, often after 11 o'clock in the morning, and either informally or formally as part of their IEP, and so they don't receive the same full 6-hour school day that children with disabilities, without disabilities receive, or other children within the school who have disabilities who aren't that particular child. So these informal methods of removal are equally as illegal as any other removal. And so I think it's really important to talk about that. If a child is prevented from attending school or receiving their educational program because of their disability or disability-related behavior, even if it is not called a formal removal or suspension or expulsion, due process applies. Now, it doesn't apply for very short removals, but removals that are significant and equal to a 10-day removal, it does apply. And so a school district is not permitted an end run around the protections of the IDEA or Section 504 or GOS by calling that removal something else. And so because we're seeing these increasingly, and we're seeing them increasingly, especially involving children on the autism spectrum, so that's why we wanted to point it out in this webinar, because these kinds of things, a removal is a removal by any other name. And so if you are representing a child and you see a pattern of these removals, it's important to treat them as though they were a formal removal. School resource officers, another issue that we're seeing a lot of. I'm sorry, next slide. I apologize for not reminding you of the slide. Some situations where we have seen success with the use of school resource officers in school is when the school resource officer's role is incredibly clear. It's clear to the officer, to the school, and to the students. And one of the ways to make that, that role clear is by using a memorandum of understanding or other written document that sets out clearly defined duties for the school resource officer. Next slide. And that role is limited to traditional law enforcement tasks related to school safety. So the police officer in the school would not do anything different than the police officer would do out in the community. They would intervene to protect student safety from true threats whether they're in the community or in the school, and that there be clarity around the evidence and interrogation standards. So that migration that we talked about earlier can't happen, that you can't have evidence that was collected under the lesser Fourth Amendment standard for school staff and that is then provided to police. The presence of school counselors and others to provide student support so that school resource officers are not being asked to do things that they are not trained to do, a positive school climate, and clarity around the use of restraint and seclusion. And Selene is going to do a nice job in a few minutes of explaining what we mean by that. But just school resource officers work better in a school setting if they are allowed to be the police officers that they are, and if those individuals who are trained as educators, like principals and vice principals, deal with the commission of traditional disciplinary infractions such as disrespectful behavior, tardiness, dress code violations, and things like that, that really are not, shouldn't fall within the purview of the school resource officer's efforts. All right, Selene, I'm going to hand it over to you to talk about restraint and seclusion.
Okay, thank you. And before that, I also wanted to point out when Diane talked about the informal removals and the protections that are afforded to students, the IDEA also talks about a pattern of removals. So even when you're looking at those 10 days, whether it's a cumulative of 10 days or it's a short or long-term suspension, you also need to look at a pattern of removal as well. Okay, so restraint and seclusion. Next slide. There is an assumption that restraints and seclusion keep people safe, and that is a faulty assumption. Next slide. We know that students can die from a inappropriate restraint. And why are we talking about this? Because sometimes in buildings, in school buildings, SRO officers or staff are restraining students for behavior that is not an imminent physical harm to that student or to anybody else. In Edith Campos's case, she was held down after resisting and refusing to hand over an unauthorized personal item, and the item was a family photograph. Next slide. There is an assumption that staff know how to recognize a potentially violent situation. Next slide. And we know that that's not the reality based on research, that looking at whether or not nurses are making decisions based on clinical cues of patient agitation, self-harm, and it was interesting that nurses only agreed 22% of the time what was inclination to assault others, self-harm, etc. Next slide. And it's just a quote that the breach between what we know and what we do can be lethal. Next slide. And so there are a number of restraints that in each state has its own, may have its own state regulations on restraint and seclusion. There is no federal law on restraint and seclusion in schools, and so schools are free to use mechanical devices that limits an individual's body movement, chemical restraints, which is the use of medication to control behavior, and physical, which is one or more people using their bodies to restrict another's movement. Next slide. And there are associated risks with restraints. We know that there is positional aphasia when you are held face down. There is aspiration when you're held face up. There's blunt trauma to the chest. There's a variety of research-based evidence that restraint is very harmful and can result in death to students. And we know that throughout the country there are students who are restrained as young as 4 and 5 years old by 4 or 5 adults. And the danger, of course, is pretty evident when you have children who are being restrained by adults in school buildings. Next slide. There's also seclusion that has been used, particularly, we know in Connecticut, that had scream rooms in a general education elementary school where students with special education needs were put in regularly and would scream, and the other children who did not receive special education services called those rooms the scream rooms. And that seclusion is the involuntary confinement of a student alone in a room or an area from which the student is physically prevented from leaving. And we know from court cases across the country that students have died in seclusion rooms when they are unattended. Next slide. So there are types of timeout. There is the chair in a general education classroom. We know about that. There's exclusion outside of the classroom, and then there is seclusion in the special room or location where you're prevented from leaving. The middle, the exclusion outside of the classroom, sometimes buildings have these learning resource rooms where you sign in and you sign out. You were sent there for disciplinary purposes. It's generally staffed by a staff person, It is a removal if you're not being exposed to the general education curriculum or you're not being exposed to teaching at that time. So that is one thing to consider in looking at those exclusion rooms. It is considered exclusion, just like when you're sent to the principal, that is also an exclusion. It is what Diane talked about, the informal removals. So it's important to look at these rooms in buildings that are called a variety of things. The learning room, the all kinds of different names that they have, and typically there are logs where students sign in and sign out, and you can see how often students are accessing those types of exclusionary rooms. Next slide. And there are risks associated with seclusion, as I mentioned. Next slide. And it is beyond our scope for today, but there is a lack of empirical research that supports the use of physical restraint or seclusion as a strategy to change behavior. We really need to look at trauma-informed and positive practices. Next slide. And these are some quick facts on restraint and seclusion in U.S. schools. At least 12 states and all of the U.S. territories, except for the District of Columbia, have no state policies or guidelines. Children are subjected to physical restraint and seclusion at higher rates than adults. Next slide. And the most glaring statistic here that comes from the CRDC data is that students with disabilities represent 12% of children enrolled in public schools, but they represent 75% of students physically restrained in public schools. And that's an astounding number, that 75% of all the kids in our public schools that are restrained have disabilities. Next slide. So there are a variety of constitutional claims to challenge the use of restraint and seclusion. There is Section 1983, which is the violation of civil rights. There's the Fourth Amendment, the Eighth Amendment, 11th, and the 14th. There's the equal protection. There's search and seizure. There's being treated differently than others. The constitutional claims, to be honest, have been very difficult for attorneys to advance in the courts, in the federal courts. The behavior has to shock the conscience, and that has been a very, very, very high standard. There is a recent case out of the Sixth Circuit where a student was gagged and left on a gurney in the hallway, and because he was a spitter, the Sixth Circuit said that it was educational methodology and was appropriate. The teacher was trying to teach him not to spit. So the Sixth Circuit said that that did not shock their conscience. So the constitutional claims have been a struggle on many of these. There was a case out of the 10th Circuit where a student broke her arm trying to get out of a wraparound desk. And again, the 10th Circuit said that that did not shock the conscience of the court. It was not a violation of a constitutional right to be free from harm during your school day. So next slide. There are claims under the IDEA for restraint and seclusion, whether or not there was an adequate IEP, whether it's a violation of the least restrictive environment requirement, whether or not there have been positive behavior interventions tried. Next slide. And then there are claims under Section 504 in the ADA, looking back at those statistics, whether or not it's disability-based discrimination that you are subjected to the restraint and seclusion based upon the disability. Next slide. And then there are claims under state law. The 10th Circuit case that I spoke of, that case went to jury trial under state seclusion and restraint laws, and the family was awarded a fairly large damages claim under varied tort claims and state seclusion and restraint laws. There's also a state case out of Washington state that COPA filed an amicus brief on that was also very successful, a violation of the state seclusion and restraint laws. they were successful. Next slide. Okay. Diane, I don't remember if, am I doing?
Yep, I've got it. So I'm going to talk very briefly about charter schools and voucher placements. We want to make sure we have plenty of time for question and answer as well. Charter schools are public schools, and so we do see an enormous number of cases involving youth with disabilities in the charter school system because of discrimination that occurs there. In short, children with disabilities who are otherwise qualified for the program cannot be prevented from attending a charter school, and the same reasonable accommodation standards apply as would in any other public setting. Once a child enters the charter school, the IDA and Section 504 protect them, same as they would in any other public school, which means that the disciplinary procedures are the same, that the IEP and service provisions are the same, and of course under 504 they are also the same. So you get an IEP with appropriate goals and services. That IEP is reviewed annually, and all those same requirements apply. We do see a significant number of cases around eligibility for charter schools that kids with disabilities are prevented from attending, or they are not placed in the lottery. You know, some charter schools have a lottery to get in because they have limited slots, but kids with disabilities are just not, their names are not placed in the lottery at all, or they are removed at relatively higher rates and then placed, you know, the family is then asked to take the child back to the regular public school because the charter school is not for children like them. So particularly for kids with IDDB, we do see a fair number of issues around eligibility in particular and getting into the school in the first place. And similarly, public voucher programs, which are increasingly popular, you know, they are public funds, so they cannot be used in a discriminatory manner. Unfortunately, what we do see in heavily voucher states is that there may not be a sufficient number of programs that meet the needs of children with disabilities that will take the voucher, or the voucher, the families of children with disabilities are expected to provide more subsidy to the voucher program than they can afford of their own funds. So there's some very significant concerns about children with disabilities in voucher systems, and we see a lot of discrimination there. There is some really great guidance recently put out by the U.S. Department of Education around charter schools and their requirements under the IDA, and certainly a developing case law in that area. And if you if you are working with a child who has had issues with either a voucher program or a charter school, you are not alone. There are lots of resources out there. So Selene and I have placed our contact information at the end. There are also a fair number of references at the end of the PowerPoint. So if you have any questions as you proceed with representing kids with IDDD, feel free to contact us and or to take a look at those references. Thank you.
Great, thank you, ladies. We had a couple questions come in during the presentation, and we have some time for folks to type in the question box if they have questions as well. Just to get us started, someone had asked if there are advocates or liaisons in schools, positioned in the school specifically, to help ensure that children's rights are not violated.
Well, every public school is required to have a Section 504 coordinator, and they do also have someone who is responsible for implementing the IDA. Oftentimes they are the same person. The special education coordinator often does both, but not always. I certainly had the experience, and my guess is that Selene has too, of asking who the 504 coordinator is at a particular school district and not getting a good, clear answer, but they are required to have one. So if I were starting that process, I would probably ask for the special education coordinator, even if it's a 504 eligible youth, and if the child is not IDA eligible, just to get the conversation started. But I also defer to Selene's thoughts on that.
No, I agree with Diane. Sometimes the 504 person is the guidance counselor, and particularly in high schools, things can fall through the cracks because typically guidance counselors in high schools write college recommendations, right, and help with that. So sometimes it's been my experience that that can definitely fall through the cracks. I had a conversation with somebody yesterday, looking at the requirements under Section 504. Section 504 has a child find or identification requirement as well as an evaluation requirement. And so it's worth noting that if you have a child who may not qualify for an IEP, whether or not then the person in the building kicks it over to whomever is responsible for 504 to determine whether or not the student needs a 504 plan.
Great. We had another question. Can a youth who has been expelled request a special education assessment? Or does that assessment need to take place prior to the expulsion?
Selene, do you want to do that one, or I can? Either way.
No, you go ahead.
Okay. Certainly, a child who has been expelled can certainly and should, as soon as possible, request a special education evaluation. As Selene had talked about earlier, there are protections for youth who are not yet eligible but should have been eligible for IDEA. So I would certainly start by requesting the evaluation right away and making the argument that the child had been should have been found eligible years ago under the child find provisions, assuming that there's, of course, any support for that premise. But if the child is potentially eligible now, chances are they were eligible 6 months ago. So I would certainly implement that protection as soon as possible. And proceed as though it were an IDEA case, for the disciplinary proceedings. But in addition, of course, under Goss versus Lopez, there are protections there as well. And one of the things that I have found because I've done a fair number of expulsion hearings, is that school districts often have not done a great job of ensuring that their witnesses are admissible, that their witnesses are prepared, that they're actually very clear about what evidence they have as it applies to each individual violation and so forth. So I think a vigorous representation just using the Goss protections can often defeat expulsions, especially in less sophisticated school districts. And so you want to invoke the 504 and IDEA protections, but even if you don't get those, there's just a lot that usually can be done in just making sure that the child had proper notice, that the evidentiary chain is clear, the violations are clear, and that the district is following its own school code and not punishing the child more strictly than other children would be or than is permissible under the school code and so forth.
Mm-hmm. There's also a recent Supreme Court case from either 2009 or 2010, the Forest Grove case with a student who had really struggled with a lot of substance abuse issues that was related to an undiagnosed disability, and the family had been told that he couldn't qualify for an IEP because he didn't have a learning disability, as if that's the only way that you qualify. And the Supreme Court did a nice job of talking about the child find, as Diane and I call it, but it's really child identification. That the school had an obligation to identify him, and they failed to do so.
Yeah, one of the more powerful provisions in the IDEA is the all areas of suspected disability. And we so often see that where the child is, they'll do a manifestation determination review based on learning disability, and they'll say, well, the learning disability does not prevent the child from setting fire to the trash can. But the reality is that the IEP is to be drafted around all areas of suspected disability, and all of those areas need to be evaluated. And so there need to be goals and protections in the IEP around all of the things that apply, even if they don't all rise to the level of an eligibility standard on their own. So that ADHD, the depression, the anxiety, those other things that might cause a behavioral issue need to be identified early on in the process and captured in the IEP and in the evaluation so that they can be used later in the manifestation if necessary.
And we have time for one more question. The viewer asked, how can folks who are in a secure facility or a training school, how can we ensure that kids with disabilities in those sort of placements get the services that they are required to get?
Well, I'll jump in here with the PNA perspective to start with, and then hand it over to Selene. The protection advocacy agencies, of which there is one in every state and territory, there are 57 PNAs. We have special rights to access, meaning we have access into institutional settings like the ones that you just described. And so in a great many states, the PNAs go in regularly and monitor in these facilities, meaning they go in and check to make sure that the educational services are being provided and that the children's rights are not being violated. In addition, we also have rights to investigate allegations of abuse and neglect. And of course, the failure to provide an educational program is a form of neglect. So if you are familiar with a situation like that in your state, a good place to start would be to contact your protection and advocacy agency. If you go to our website, www.ndrn.org, you can, there's a Find Help in Your State feature right there. You can find out where the PNA is and contact them and let them know you might have neglect, a neglect case, if that is in fact the case. But so that's one way to go about doing it. But of course, there are lots of other ways too. So I'll hand it over to Selene for the rest.
Yeah, I think it's what Diane said is absolutely true. I've had the PNA come in and investigate when there have been restraint and seclusion issues with my individual clients. But also, COPA has been training and does do training of public defenders, trying to train as many public defenders as we can, as well as legal aid attorneys, about special education and ways to advance students' rights, particularly students who are in alternative programs, students who are incarcerated, students who are in those training schools. So it really is about the knowledge that attorneys bring to these, the knowledge of special education and the rights that students have that can, if you effectively advocate, that can change their lives and hopefully get them on the road to appropriate transition services, which are so important, which Diane and I didn't talk about today, but the transition requirements of the IDEA are really robust, and many of us, and I'll take responsibility, attorneys are just beginning to realize how important those the effective transition plans are for students as they exit school.
Great. Well, thank you both for a wonderful presentation today, and thank you for everyone who is with us online. If you need a certificate of completion for participating in today's webinar, please send me an email at smoot, S as in Sam, M as in Mary, O-O, T as in Tom, at juvjustice.org. The webinar's recording and slides will be posted on our website at juvjustice.org within the next 24 hours. Thank you to everyone, and have a great weekend.
Thank you, Naomi.
Thank you.
Thanks, Diane.
Thank you for inviting us.
Okay.
Yes,
thank
you.
you.
Take care.
Thanks. Bye-bye.